Here's a clip from the United States Supreme Court, a colloquy between an attorney and Justice Brett Kavanaugh discussing how to interpret BRUEN, which is exactly how I've taught, that you look to historical analogues from 1791, when the Second Amendment was adopted, and to the extent you want to look at anything later in the 19th century, like after the Civil War, you can only do so to the extent it's a confirmatory analytic, or it confirms your original understanding of 1791, and nothing, I repeat, nothing about the late 19th century historical analogues or otherwise can undercut or shrink the original meaning and scope of the Second Amendment's right to keep and bear arms. Don't take my word for it. Check this out from the United States Supreme Court case, Moore versus Harper.
What about the historical practice over time, which has certainly developed in a way that state constitutions do regulate federal elections? What weight, if any, do we place on that?
Your Honor, we think the way to think about this is consistent with the Court's opinion in BRUEN last term, where it looked very focused on the time of the founding, 1791. Obviously, we're looking for the public meaning of the Constitution as that founding generation passes away. Adams and Jefferson die on the 50th anniversary of the Declaration of Independence. As we get out of the 1820s, there's very limited information you can get as to the original public meaning of the Constitution. But so it can be a confirming that subsequent history, as in BRUEN, can be a confirming historical tradition, but it can't undermine what the text and the founding era history show to be the case.
Thank you.
Hope you found that interesting. You cannot use the 19th century to undercut the scope or the meaning of the Second Amendment as understood in the founding period of the late 18th century.